Hello and welcome to anyone watching this case analysis. The case we will be discussing today is Visa Cancellation Applicant and Minister for Immigration and Citizenship. Before we begin, it is worth mentioning that some of the evidence provided to the tribunal during the proceedings contained sensitive information about the applicant's children. For this reason, the applicant and the children's identity have been protected. In this case, the delegate for the Minister of Immigration and Citizenship cancelled the applicant's visa on character grounds. The applicant referred the decision to the Administrative Appeals Tribunal to reconsider the matter. The tribunal held that the minister's original decision would be upheld. As a consequence of this decision, the applicant was required to leave Australia and return to New Zealand. We systematically agree with the tribunal's decision. In this video, we will discuss the reasons for that decision, why we agree with it, and analyse the overarching issues of administrative law which were considered during that decision.
Before delving too deeply into the administrative issues at hand, it is important to gain an understanding of why the applicant's visa was cancelled in the first place. The primary decision was made by the Minister for Immigration and Citizenship, who was granted a discretionary power to cancel Australian visas. This decision was made by the Minister's delegate on character grounds under Section 5012 of the Migration Act 1958. In accordance to this section, the delegate found the applicant did not meet the character test because he had a substantial criminal record where he was sentenced to a term of imprisonment of 12 months or more. The applicant had previously served 9 years and 3 months imprisonment for manslaughter and sexual violence by rape, 4 years imprisonment for assault with intent to avoid detection, and 2 years imprisonment for wounding with intent to injure. These sentences were also in addition to numerous other lesser convictions. The decision of the Minister was appealed to the Administrative Appeals Tribunal, which has the power to review administrative decisions of the Executive.
The Administrative Appeals Tribunal conducts independent merit review of administrative decisions made under Commonwealth laws. A merits review body makes its decisions within the same legislative framework as the primary decision maker and may exercise all the powers and discretions conferred on the primary decision maker. The process of review may be described as stepping into the shoes of the primary decision maker. Under the Migration Act 1958, which is the relevant statute to this case, the AAT has the power to affirm the primary decision, vary the primary decision, set aside the primary decision and substitute a new decision, or remit a matter to the Department of Immigration and Border Protection for further reconsideration. The principal objective of merits review is to ensure that those administrative decisions in relation to which review is provided are correct and preferable. This notion of correct and preferable is a primary overarching issue relating to this case at hand. Correct refers to the legality of the decisions, and preferable refers to the best decision where there is a range of possible decisions that are correct in law. Let us now look more closely at the notion of correct and preferable and how it was determined in this case.
Now let's discuss the notion of the correct and preferable decision. When deciding a case, the AAT looked at previous cases such as Shy v Migration Agents Registration Authority, which affirmed that the question for the tribunal was whether the original decision made by the Minister was correct and preferable. The question in this case was whether the Minister made the correct and preferable choice when cancelling the applicant's visa. In deciding to uphold the Minister's decision and cancel the applicant's visa, the AAT was exercising its general discretion. The essential characteristic of a discretionary decision is that there are alternatives which are also as equally lawful. As we stated earlier, the AAT could have reached a number of different outcomes in its choice. In these types of decisions, it is the AAT's responsibility to provide correct and preferable outcome with regards to the applicant and the community at large. Reaching the most correct and preferable decision does not imply a subjective test, nor does it allow for personal inclinations or beliefs to affect an outcome. Often, the only clearly applicable measure or touchstone is the public interest. This employs reference to the community standards or values, not the decision maker's personal or idiosyncratic view. In a plural society, this is This has been a matter of controversy, but it should be kept in mind that the community values do not depend on transient or fashionable thinking, but more on permanent values.
This brings us to a discussion about the doctrinal ambiguity of administrative law which arises out of this case. It relates to the nature of discretionary and administrative decision-making and the aforementioned notion of the correct and preferable decision. If a correct and preferable decision is made with regard to community standards, how does a tribunal determine what community standards are? We have discussed in administrative law, decision makers are required to consider the severity of the facts with regard to community standards. However, community standards are always changing, and there is no set method to determine a community's moral, ethical, and overall cultural ideals. In this regard, and especially in the absence of evidence, a decision maker's authority in assessing the right standard has been a contentious issue. Previous to this case, little has been said about how to assess community values. The case contributes to administrative law by clarifying that community standards are to be found in the permanent values of society. It finds decision makers should be informed of community standards in part by legislation of the parliaments and especially by legislation applicable to the decision making. Formal statements by ministers are also relevant, but not when they are not speaking officially or when their remarks are not carefully considered or do not appear to reflect a broad consensus of opinion. By helping clarify what was previously an ambiguous doctrine, this case has contributed to administrative law by acting as a precedent for future cases which may need to consider the correct community values and standards.
In summation, we can argue that decision makers live in the same world as the rest of society, so they can draw on personal experience. The thing is, these decision makers also have the added advantage of being able to draw on knowledge gained through their learned insight into the intricacies of legal history. It is important to recognise that the adjudicator, in deciding the correct and preferable decision in this case, drew from all this experience. The courts have grappled with the role of community values in judicial decision-making for some times, but comparatively, little has been said about the work of tribunals that are charged with making the correct or preferable decision. Tribunal members have scope to refer to what Dyson Hayden recently described as non-legal experience. Justice Downs, the President of the Administrative Appeals Tribunal, suggested in 2011, before his retirement, that community standards must assume an even more significant role in the deliberations of the tribunals compared to courts. His Honour concluded tribunal decision makers should proceed cautiously when referring to non-legal experiences, yet it is necessary to reach a decision for the greater good of the public and its community. Before delving too deeply into the administrative issues at hand, it is important to gain an understanding of why